The motion to release the defendant on bond prohibit the state from using certain evidence at trial based on the state's failure to disclose favorable evidence. This court is entering an order today to deny that motion. I've done so under a Richardson analysis, which I indicated earlier. The issues brought up by the defense related to discovery, this is without prejudice. So this issue remains here to resolve any of those issues, okay? But as far as the motion that has been filed, I'm denying that, okay?
Shanna Gardner trying to get out on bond prior to her murder for hire death penalty trial, denied by the judge. Denied by the judge. And her parents have lots and lots, I mean, tens of millions of dollars, very successful business that they own. This is a case out of Jacksonville. So there were other arguments in court today, and they're alleging that during the grand jury, when they presented evidence in front of the grand jury to get the indictment against Shanna Gardner, that one of the witnesses for the state perjured themselves. So let's take a listen to the arguments made by the defense and then the response from the state.
Court's aware that they received, that the state made a representation to Detective Johns about 3 checks. The checks initiated, or the funds allegedly initiated from the trust of Shanna Gardner. What the state did not argue or present clearly to the court as part of this misrepresentation is that the trust funds that they presented were from 2021. The checks to Tenon were in 2022. They also made a representation to the court of a truck that was driven by Tenon, and an allegation that only the individuals involved with the murder for hire would know about this truck. Why is that a problem? Because they failed to demonstrate to the court or show to the court that the roommate, Ordway, was well aware of the connection based on testimony or based on an interview by law enforcement. There's the text messages that Detective Johns was well aware was based on a joke from some 20 years prior. And what did the state present to the court? Text messages, absent the context that this was a very old joke, absent the context that there was a text marked LOL. So to say that this is mere speculation when we can point to verified instances of misrepresentations by Detective Johns before this court, and knowing that he is the main witness, or at least it appears he's the main witness before the grand jury, his testimony has been perjured. This isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already, and it's a fair connection to say that he's made similar, or if not greater, misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns. So for that reason, Your Honor, and based on all the argument that's before the court in this written motion, we're asking for the court to unseal Detective Johns' testimony.
They're talking about testimony that came out at a bond hearing regarding the detective's testimony on hearsay. So he's saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues that he's out through discovery. So I think at this point, they're saying what they perceive to be misrepresentations, which I disagree with. I think the two parties can look at evidence differently, have different theories of a case, different theories of evidence. That's why we have a justice system and trials. They're saying that they believe Detective Johns' testimony is inconsistent with their theory of the case, and therefore there must be, or potentially would be, other misrepresentations in his grand jury testimony. That's a speculative statement without any specific substantive or particularized merit.
I want the state, okay, to take a realistic look at how you believe this case, how much evidence you're going to put on. I'm gonna block y'all off, and it's going to be a while from now. Additionally, I'm putting these things out there. I want to know when you all believe that you can have your capital litigation prepared in order to submit to the court, okay? I want to know from the state's perspective how long you believe this case needs to be tried. The question in my mind is logistics, okay? Is there going to be an ask for sequestration? I need y'all to start talking about these things, okay? And then additionally, when we get the jury selection date, realistically, with the logistics and the number of lawyers, how long y'all believe jury selection will take, if you want to utilize, how many jurors, things like that. I need y'all to start talking about those things. And we are, I know that you all have been focusing on the guilt phase, but we need to start thinking and setting court dates that are going to take up a lot of time, a lot of resources.
Okay, Darnell, this is a case where you're going to have a very well-funded defense. I think we're seeing it already, bringing some of these motions. How different is it? How much of a game changer is it? And in a murder for hire case where she's the top of the food chain, could it backfire on them knowing that she's the one with all the money?
Well, it was funny because the judge seemed to sidestep the entire motion, which I thought the argument by defense counsel was brilliant. It was well thought out and it had a rhythm that one could connect with. And the judge then responds to talk about scheduling and how long the trial will be, all these things, that didn't even respond to the motion. The motion was tantamount to me to be one where it's like when you're applying for a warrant. And we have this thing called a Frank's hearing if you want to challenge the application for the warrant. Anything that's left out of the application or that's put in there that shouldn't be in there can be challenged if, in fact, the judge was misled by something or something was left out. So in this particular case, if the grand jury was presented with information and the detective was lying and perjuring himself and wasn't telling the truth, then this grand jury could have come back with a true bill that was based on false information. So I think the judge should have really squared in on whether that was true or not. And the defense attorney was saying basically like, well, judge, this motion is for you to release us that information so we can verify this. And I think it was a fair motion. In terms of her family having a lot of money, I don't think that's enough just to say because she's rich, she did a murder for hire because, it doesn't take that much these days to get somebody to want to kill somebody.
Yeah, he knows the marketplace, apparently. Oh, darn. Jennifer, Jose Baez is in on this case. Jose Baez went up to Massachusetts. I don't know how he did this one, with a guy who had already been convicted of murder and convinced the jury they didn't commit another murder, even though he was there, which was pretty amazing. And there was video, et cetera, of him at the house with the weapon. But to me, that's part of the defense here, right? They can afford Jose Baez. They can afford co-counsel. They can afford the investigation that is necessary. And you've got two other co-defendants here that you can point the finger at. One is pleaded guilty. The other one doesn't have two nickels to rub together unless he gets something out of the divorce. So is this a big advantage for Shanna Gardner going into this case?
Well, she's going to do everything she can to defend herself, just like anyone else would. And if you have the resources to do it, yeah, why not hire the best counsel that you can get? There's some serious charges being leveled against her, and she wants the best defense possible. So you can't really fault her for that. She's doing whatever she can to protect herself, just like most defendants do in these cases. So
well, it's really her parents, not her. It's her parents. Let's be honest.
Regardless,
she hasn't done anything.
Yeah, but Vinny, family members often chip in to support their loved ones.
Oh yeah, for sure.
I don't say that's not a problem. I disagree with Darnell in that, having the resources, maybe it does make it more likely that it was a murder for hire and that she had the money to hire somebody. So I don't know. Darnell knows better how cheap or expensive it is, but it seems to me it would be kind of expensive. So
Randy, I don't know. Is her defense going to be that my new husband did this without my knowledge? It was like a gift for me that I didn't ask for?
So, you know, I'm going to go back. I'm going to thread the needle between Darnell and Jennifer. And the nice thing about having money, you can do a lot of things that these, you know, impoverished defendants can't do. You can have a mock trial. You can actually present your theory to, you know, imitation jurors and see what they think and what they listen to and what they pick up on and what theory works. So that may very well be the theory, although they get 12 jurors that say, you're crazy, I'm not going to buy that. Then they throw that theory out the window and they go on to the next one. But yeah, having good counsel and having resources absolutely does change the game.
You can afford
sometimes.
one of those lawyers who has like a mock courtroom in his office.
All right, Vinny, come on. We're going to call those vinning arguments instead of closing arguments, huh?
There you go. Darnell, do you have a mock courtroom in your office? Because I think Randy does.
Well, that's why I win on my trials, because I look at the real courtroom as a mock courtroom, because I think it's all fake anyway.
There you go. All right. And just to tie this up, because this all started, Jennifer, in family court, right? The theory of prosecution is this is a custody battle. But this is 7 years after the divorce, so these things never end, do they?
never end, Vinny. Randy and I can tell you that they go on and on and on, especially with children being involved, and then those children grow up and grandchildren and so on and so forth. You see it time and time again. Emotional, and emotions can turn very, very ugly. That's for sure.
Absolutely. Randy Kessler, Darnell Crossland, and Jennifer Brandt. We're out of time. Sorry, Darnell.
I just want to say, Jose Bias and I are both from the Bronx.
From the Bronx. There you go. I don't know if that's good or bad.
Darnell can use our courtroom anytime he wants.
Okay. Big thank you. When we come back, I will reveal